Hello, welcome to another TenderCom video. Today we will be discussing the Complete Guide to Protection of Personal Information Act, South Africa. We will be discussing what is personal information, transfer of personal information outside of South Africa, 8 conditions of Popi Act, how to comply with Popi Act, penalties or fines for non-compliance. Popi is simply a data protection law that seeks to protect individuals and juristic persons from the harmful effects of the unauthorized use of their personal information. The Popi Act is sometimes referred to as Popia, so do not be confused when these terms are used interchangeably. What is personal information? According to the Popi Act, personal information refers to information that pertains to an identifiable, living natural person, and where applicable, an identifiable existing juristic person. Personal info includes, but not limited to, information relating to the race, gender, sex, marital status, nationality, birth of the person, etc. Information relating to the education, or the medical, criminal, or financial history of a person. Any identifying number, symbol, email address, online identifier, or other particular assignments to the person. The biometric information of a person. The personal opinions, views, or preferences of the person, the name of the person, if it appears with other personal information relating to the person, or if the disclosure of the name itself would reveal information 20 about the person. Transfer of personal information outside of South Africa. The Popia Act specifically prohibits the transfer of personal information outside of South Africa to another third party in a foreign country unless in the following circumstances. The data subject has consented to the transfer. The transfer is necessary for the performance of a contract between the company processing the information and the data subject. The transfer is necessary for the conclusion or performance of a contract concluded in the interest of the data subject between the company or responsible party and a third party. The transfer is for the benefit of the data subject, and it is not reasonably practicable to obtain their consent of the data subject, and if it was practicable to obtain consent, such consent would likely be given. The third party must be governed by a law, binding corporate rules, or an agreement that ensures an adequate level of protection for personal information, aligning with the principles of the Protection of Personal Information Act, Popia, including provisions for further transfers of personal data to other third parties. 8 conditions of the Popi Act. The Popi Act sets out 8 conditions for the lawful processing of personal information. Condition 1. Accountability. The entity needs to ensure that processing of personal information is lawful and that there is a person responsible for the compliance with Popia and maintaining up-to-date record of information processed. Condition 2. Processing limitation. Personal information must be processed lawfully and in a reasonable manner by ensuring that only authorized information is processed for the purpose for which it was intended. It's relevant and not excessive. Condition 3. Purpose specification. Entities must inform owners of personal information about the purpose of collection, how it will be used, and ensure the information is collected for specific, defined purposes related to the entity's activities. Condition 4. Further processing limitation. Any further processing of personal information must still be in accordance with the original purpose for which the information was collected and to which the data subject gave their consent to. Condition 5. Information quality. The entity must ensure that all personal information collected is of quality by being complete, accurate, up-to-date, and not misleading. Condition 6. Openness. Data subjects must be always made aware that their personal information is being collected, as well as the purpose for which their personal information is being collected. Entities are by the same token required to maintain proper documentation of all processing operations. Condition 7. Security safeguards. Entities must implement security measures to protect personal information from loss, unauthorized access, modification, use, or disclosure, and report any unauthorized access to the information regulator immediately. Condition 8. Data subject participation. Through the data subject participation condition, entities must ensure that data subjects have the right to access, modify, and delete their personal information. How to comply with the Popi Act. 1. Appoint an information officer. Every entity must appoint an information officer with the information regulator to oversee compliance with the Popi Act, handle privacy requests, and cooperate during investigations. It is recommended that the CEO or deputy take on this role. 2. The information officer must conduct a personal information impact assessment to review the entity's data practices, ensuring compliance with lawful processing conditions by evaluating data collection, security, usage, and disposal, particularly in marketing. 3. You need to develop or update your PAIA manual in terms of the Promotion of Access to Information Act, which requires all entities in South Africa to have it. The PAIA manual clarifies to data subject steps they can take to have access to their information held by the entity. Draft a privacy policy. Always have it on your website. 5. Conduct a Popi awareness training session within the entity to educate your staff about the provisions of the Popi Act as relates to what information can be collected, stored, shared, and what to do in the event of a data breach. 6. Ensure agreements with third parties processing personal information include adequate security measures to protect data as required by the Popi Act. 7. Ensure that all employees that have access to clients' personal information or process such information sign an undertaking to comply with the Popi Act. 8. Obtain consent from data subjects. Inform them about data usage and sharing and provide an option to opt out. 9. Maintain documentation of all processing information. Penalties or fines for non-compliance. Non-compliance with the Popi Act leads to a fine of up to 10 million rand or 12 months imprisonment, or both a fine and imprisonment. Join thousands of happy and satisfied Tendercom clients who've got quick, affordable and professional services such as company registration, tender documents, compliance and more. Visit our website for more info and contact us for any queries.